Good afternoon, and I am Barrister Taposh Kanti Baul, the moderator of this session. Would like to welcome you all in this afternoon session of the Global Conference, which is organized by Liberation War Museum. And the theme of the conference is commemorating past genocides and learning to prevent atrocity crimes. And in this session is jointly partnered by ELCOP, which is Empowerment Through Law of the Common People. And the theme is understanding the barriers through transitional justice lens to ensure justice, the experience of Bangladesh and beyond. Just in the beginning, very shortly, I want to introduce Empowerment Through Law of the Common People, which is a brainchild of Dr. Mizanur Rahman, Professor of Law of University of Dhaka and former chairman of National Human Rights Commission. ELCOP mainly organizes Human Rights Summer School for the law students of Bangladesh and organizes community law reform and street law program. So with this short introduction, I would like to call the first speaker. The first speaker is S.M. Masum Billah. Before I introduce S.M. Masum Billah, I would like to just say that every speaker will have 12 minutes for presenting their papers. And after that, we will have a Q&A session. All the participants are welcome to ask questions. I'll put the questions to the speakers and they will answer your queries. So with that, I will introduce Dr. S.M. Masum Billah. He teaches law at Jagannath University, Dhaka. He did his doctorate from the Faculty of Law, Victoria University of Wellington. He is an alumnus of Rajshahi University. Dr. Billah, the floor is yours.
Thank you. Thank you, Barrister Ball. My esteemed co-presenters, Advocate Ziad Al-Malum sir, and Vera, who has joined us all the way from Geneva, and their audience. My topic today is alibi plea, international practice and its application in ICTBD, that is International Crimes Tribunal for Bangladesh. Can you see my slides? Because I'm trying to show some slides.
Yes.
Yes, thank you. Some introductory comments. The International Crimes Tribunal Bangladesh, which has been functioning from 2010 onwards, has done a commendable job and achieved some milestones, but at the same time it has suffered some legal and extra-legal criticisms. And at the same time, it has been a subject of legal study and research globally. The practice of alibi in Bangladesh system has drawn attention both domestically and internationally. And it has received arguably some undue criticism by scholars. Geoffrey Robertson, QC, for example, in his 2014 report has criticized the application of the doctrine in Bangladesh. And he has seen the alibi issue as from the lens of the fairness. And in majority of the cases so far decided, already the ICTBD has decided 42 cases, and in majority of the cases, the defense has set the plea of alibi. As all of you know, that alibi is a popular excuse in criminal trials. The word literally means elsewhere. It is a claim by the defense that an accused was not present at the crime scene when the offense in question was committed. Robertson wanted to see it through procedural fairness, while Noops has argued that it is a kind of distinctive defense in criminal trial. This was famously invoked in Kader Mullah case, Kamruzaman, Ali Hassan Muhammad Mujahid, and Salahuddin Kader Chaudhry, 2015. So we can understand that the defense has been decisive in Bangladesh trials. Now, let us have a look at the Bangladesh approach. Rule 51 of the Rules of Procedure of the ICTBD has said the onus of the proof is as to the plea of alibi shall be upon the defense. And Justice S.K. Sinha, as he then was in Mullah case, observed that the burden of proving the special defense of alibi is on the accused setting it up. Now, this provision and observation has invited certain criticisms. For example, Robertson has referred to Zigira Niarajyo, pardon my pronunciation, of the ICTR case. He has claimed that this approach of the ICTR was actually correct. Where an alibi is properly raised, the prosecution must establish beyond reasonable doubt that despite the alibi, the facts alleged are nevertheless true. Now, you see a contrast between the stand of the ICTR and the Bangladesh practice. As such, the critics have said Bangladesh position is wrong and compromises procedural fairness and not supported by common law and international law, and it overlooks the principle that burden of proof remains on the prosecution. Now, if we actually have a broader look, what happens? As far as the onus of proof is concerned, we can say that the defense to prove the plea beyond all reasonable doubt, this criticism is not actually fully correct because it does not relieve the prosecution of establishing their case beyond all reasonable doubt. Rule 50, sub rule 3 of the Rules of Procedure says, mere failure to prove the plea of alibi by the defense shall not render the accused guilty. So the appellate judges, and that means the judges of the appellate division of Bangladesh Supreme Court, frequently mention in this in their deliberation. For example, Justice M.A. Wahab Mia, the dissenting judge in Mullah appeal, even put more emphasis on this conjunctive reading. As such, in order to understand the real position of Bangladesh, a conjunctive reading of Article 50 and sub-article 50, sub-article 3 should be ensured. Now, let us see the full paragraph cited by Justice, written by Justice Sinha in Mullah appeal. Under our criminal jurisprudence, the accused is presumed to be innocent until his guilt is proved. He is not required to prove anything. The burden is always upon the prosecution. Adding to it, the burden of proving the special defense of alibi is on the accused setting it up. The appellant in this case, that means in Mullah case, failed to create reasonable doubt to the possibility of his being absent in the scene of the occurrences. Rather, it has been established that he has very much present in Mirpur and masterminded all the killing and other heinous crimes against humanity. So, as per Justice Sinha, the duty of the defense in alibi plea is to create a reasonable doubt on the possibility of the accused's presence at the place of occurrence. This has been misquoted by the critics, especially by Geoffrey Robertson. So, in Mullah case, Justice Sinha's standing here in Musaima. The usual common law and international practice requires a notice from the defense to the prosecution expressing defenses in 2001 case. The purpose of setting the plea at an earlier stage is to enable the prosecutor to consolidate evidence of the accused's criminal responsibility with respect to the crimes charged. But on the contrast, Bangladesh model has three dimensions. I believe same is the thing with other subcontinental country. Burden of proof, firstly, Bangladesh practice says burden of proof of the whole case is on the prosecution beyond all reasonable doubt. Secondly, is said that the credibility of the alibi claim is to be established by the defense. Thirdly, it interestingly says failure to establish the plea does not lessen the burden of the prosecution. So, on top of this, the accused is presumed to be innocent until proved guilty. So, taken as a whole, Justice Sinha in Molla referred to this principle that the burden of proof is on the one who declares, not on who denies. In the as ICTBD, in the same case, the trial court, Justice Obaidul Hassan borrowed from ICTY jurisprudence where applicable to understand the nature of the principle. So, if a defendant raises an alibi, he is merely denying that he is in a position to commit the crime with which he is charged. That is not a defense in its true sense at all. By raising this issue, the defendant does not more than require to prosecution to eliminate the reasonable possibility that the alibi is true. Molla Tribunal Judgment, page 124. In academia, we see that, for example, Shane Durkee has said in Shabazz edited paper, RT chapter says, in raising an alibi for an accused, there is an evidentiary burden for the defense to extent that there must be indicate proof to raise a reasonable doubt, although the burden of proof overall clearly remains with the prosecution. Thus, the Bangladesh approach does not deviate from international recognized procedural fairness of alibi notion. It is rather a contextualized practice of the alibi notion, I argue, is deeply embedded in the criminal justice system of the Indian subcontinent. In Molla case, Justice Samsuddin Chaudhry Manik observed, having compared the testimonies of the defendant witness, all of whom basically tried to prove the appellant's alibi, I have detected catastrophic discrepancies capable of rendering their version to nullity. As such, the court also relied upon the overwhelming evidences produced to cut off the plea of alibi. In Salahuddin Qadir Chaudhuri, the defense offered an interesting story of alibi. The accused claimed that he had been studying at Punjab University for studying, de facto located at a different country, 1,000 miles away from the place of occurrence, the then is Pakistan. The minimum duty of the accused then was to submit his certificate of award to the court's satisfaction, which he failed. The court found that the plea is concocted, false, and unbelievable. Firstly, he submitted two versions of testimonials from a professor of Punjab University. Secondly, the examination year and the reading session were inconsistent with each other. And thirdly, the prosecution established contradictions in the witnesses depositing during the cross-examination. The prosecution then produced corroborative evidence, newspaper reports supporting police record of relevant time, and testimony of a doctor who offered medical treatment in accused injury to show the physical presence of the accused in his locality to commit the atrocity charge. Thus, despite the alibi, prosecution proved the case beyond all reasonable doubt, an alibi approach taken by the ICTY in Nitejeka case. So, the Chaudhuri alibi approach of the Bangladesh Supreme Court also goes at par with the ICTY approach in Tajik, where the ICTY rejected the plea of alibi raised by the defense in view of the overwhelming credible testimony to the contrary. Mujahid and Kamruzzaman case is same. I am overlooking it. So, Bangladesh practice and other jurisdictions, actually alibi is potentially a pejorative term that continues to vex the trial process in international criminal tribunals as well. As such, the ICTR and ICTY have offered competitive interpretations, and arguably the doctrine is still under construction. So, in order to fill up the gap, the national practice should have a say. In many national jurisdictions, judges do exercise greater freedom to interpret alibi law to prevent the misuse. I have referred from Australia, Canada, South Africa, United States, England, and Scotland to support Bangladesh's position. So, Bangladesh model of alibi deserves a better reading. So, I want to offer some concluding remarks by saying that Bangladesh rule of alibi does not fall short of a standard from the usual ICTR and ICTY practice, though it coached in a different model. Secondly, Bangladesh model, in spite of a substantial compliance with established rules of alibi fairness, sustains an unfair criticism and misreading. Thirdly, the defense in Bangladesh has a tendency to use the plea of alibi as a strong form of defense, whereas international commentators generally agree that it is a wrong kind of defense before the tribunals because it has succeeded only in one case to date. Too much reliance by the defense suggests that they lack other strong evidence to disprove the allegation. However, this is not to argue that Bangladesh should stop learning from fashioning new jurisprudence on alibi. Bangladesh may enlighten itself by the rules of international alibi practice only to the extent it suits with its context and benefits its judicial practice and does not compromise the notion of fairness. It should be ready to further develop its jurisprudence in such a manner that the plea cannot be used as an avenue to escape guilt. So with this, I end my presentation. I will be able to address any other question when the session will be open. Thank you so very much.
Thank you, Dr. Billa, for concluding on time, just taking 1 minute more, you know. Now I will be requesting Vera Iovesan to submit her paper. But before that, I would like to say a few words about Dr. Billa's presentation. He has presented the 3 dimensions of Bangladesh model of alibi, which actually showed that the ICT-BD approach does not deviate from the international standard. This statement has gave the ICT-BD a great shows that how great its achievements are in the international criminal law and thus in international law. So thank you, Dr. Billa. And now, Vera, if you can hear me, so
yes.
you are going to present your paper on gender-based persecution, the case of Al Hassan at the ICC. This is one of the hotly debated issue right now in the international criminal law arena. Vera is a PhD candidate in international law at the Graduate Institute of International and Development Studies, Geneva. Her doctoral research focuses on the cultural defense in international criminal trials. Vera holds a master's degree in international law from the Graduate Institute and a combined bachelor and master's degree in law from Bocconi University, Milan. So with these words, I would like to invite Vera to present her paper.
Thank you so much, and thank you so much for inviting me today. I'm very happy to be a part of this. As you just said, I will be talking about persecution on the basis of gender and the case of Al Hassan. So we are going to be moving towards Mali and the ICC. So among the different charges that have been put for Al Hassan is also persecution on the basis of religion and on the basis of gender. And especially the persecution based on the basis of gender is very relevant because it's really a first for 2 separate reasons. On the one hand, the ICC, the Rome Statute of the ICC, is the very first international criminal law instrument to include persecution on the basis of gender in it, to include it as officially. So beforehand, all the way from in the International Military Tribunal, when we talked about persecution, it would be on the basis of politics, race, or religion. That was pretty much kept in the ICTY. The ICTR changed things a little bit and talked about crimes against humanity that had to be that had to happen within the context of an attack which had to be based on national, political, ethnic, racial, or religious grounds, so still no gender. And the ICC with Article 7.1h is the very first one to include gender and also cultural grounds, or also have a open clause of other grounds that are universally recognized as impermissible in international law. This is interesting because when we think about persecution, we immediately think about discrimination, and I'm sure wherever we are from, all of us have, we constantly talk about discrimination on the basis of gender, especially towards women. And so we are very sort of attuned to this discourse. And even in international law, for example, when we talk about refugee law, we tend to think of persecution also on the basis of gender. Although even in refugee law, actually gender is not one of the officially recognized grounds, although we have been having sort of guidelines that have included it since the 1980s. But in international criminal law, we really didn't have it explicitly up until since 1998. But even from 1998, so in the 22-year history of the ICC up until now, we never had a case in which the charge was confirmed. We did have a case before in which persecution on the basis of gender was charged in 2009, but then the charges were not confirmed. So this is the very first case in which persecution on the basis of gender will be discussed or is being discussed in front of the court. Now, to give you very briefly the context of what is happening or what happened in Mali and who Alassane is. Alassane was the de facto chief of Islamic police of the armed group Ansar Dine, which operated in Mali together with Al-Qaeda and basically controlled several areas, including Timbuktu, from April 2012 to January 2013 within the context of an international armed conflict with the Malian armed forces. And obviously, when we talk about persecution in that case specifically, that is also on the basis of religion, of persecution in that context is also on the basis of religion. So that includes the targets were both men and women. But then when we move towards gender is because women were really targeted because of their gender and were controlled and repressed. So much so that the Office of the Prosecutor in their opening remarks at the opening of the trial talked about a complete and total control and domination on part of the Islamic police and of the Ansar Dine. And the kind of things that were happening were the fact that women, for example, were made to wear a veil or cover their head, their bodies. They couldn't walk out freely. Not at night, they couldn't meet amongst themselves. Their life was really turned upside down in all of a sudden. And if they did not comply with these new rules and regulations that Ansar Dine imposed, they were severely punished. They were flogged, hit, and lawfully detained in small, hot, overcrowded places. There's been stories of women being detained in 2x2 small ATM rooms, up to 12 of them, with no access to sanitary facilities. And they were also very, very extensively victims of forced marriage and rapes, and rapes that was both in detention and outside of detention. So obviously, all the rules that I mentioned, they do amount to violations of fundamental rights, which is what we need for persecutions. So that would be violations of the right to privacy, bodily autonomy, freedom of expression, freedom of right to private property. But at the same time, then we also have to have a connection to other crimes within the jurisdiction of the court, and that would be torture, cruel treatment, and other inhuman acts, rape and sexual slavery. So it seems that at least at the level of the charges, we do have a reasonable basis to believe that these facts happened. Now, though, what will be where we have to look going forward is how several of the issues will be looked at from the court, because we don't really have case law on this. And the two main issues that I could identify and that the commentators have identified are the issue of gender and the issue of intersectionality. So gender is defined in paragraph 3 of Article 7 on crimes against humanity. So we have the mention of gender when we talk about persecution, and then the statute defines it as, for the purposes of this statute, it is understood that gender refers to the two sexes, male and female, within the context of society. This definition has been defined by Valerie Osterveld as constructive ambiguity, meaning that some states, we had a situation in which there were states that were very conservative and states that were very progressive, and we had to find a compromise between the two. So there were some states that sort of believed that by gender we should mean biological sex, and there were some states that actually were quite progressive with their understanding of gender and sort of thought about expectations and stereotypes, and that is what gender is, not so much connected to biological sex. And the statute really didn't take too much of a stance on this, sort of trying to accommodate both views. We do have the opinion and the stance of the Office of the Prosecutor, because when Fatou Bensouda sort of issued a policy paper in 2014, where in which the Office of the Prosecutor says that the definition acknowledges the social construction of gender, the accompanying roles, behaviors, activities, attributes assigned to women and men. And talking about gender-based crimes, says that those are those committed against persons, whether male or female, because of their sex and or socially constructed gender roles. So that clearly is more attuned to the more progressive understanding of gender that would take into consideration much more than simply biological sex. And what the court can do and hopefully will do when deciding this case will be to define gender. We don't know exactly how much less ambiguous it will be than the statute, but it most likely will have to come up with some sort of interpretation. Now, according to some commentators, for example, Rosemary Gray, the court is bound to sort of follow the lead of the OTP, because according to Article 21.3 of the ICC Rome Statute, the court is bound to interpret the law of the statute as comporting with in international recognized human rights law. And in human rights law, there's more of a like the understanding tends to be quite progressive. The understanding of gender tends to be quite progressive. The point, though, when we talk about this and the importance is not so much for Alassane, maybe in the Alassane case, but what it means for the jurisdiction of the courts, really. Because if we intend gender as something that is strictly connected to biological sex, or something that is very much of a socially constructed identity, that is two very separate things, that could, and if we take the second approach, that could open up to the court to having jurisdiction to persecution on the basis of gender, that would include, for example, persecution on the basis of sexual orientation or gender identity. So something that it's not necessarily as obvious as, well, even it's not necessarily obvious if we just look at the statute, so it does need interpretation. And the second point that we really need to, that we hope to receive some guidance from the court is the point of intersectionality. Just to give you an idea, like to keep everybody on the same page, intersectionality is a concept that was coined by Kimberly Crenshaw in 1989 and is used to describe overlapping social identities. So we would have, so in her case, she wanted to describe African-American women and their particular situation. And what happens is that one person, one individual may be oppressed from the point of view of several different, because of several different social identities. So for example, in the case that she mentioned was being women and being Black. But it is not simply the sum of these different harms, because the harm that the one person who finds themselves at the epicenter of these different social identities, the harm that they suffer is actually much more than the sum of all these harms. And that is very relevant in the case of Al-Hassan, because we have two different ways of looking at of intersectionality, because there's one which is somewhat explicit in the sense that persecution against Al-Hassan he's been charged with persecution on the basis of religion and of gender. They are separate, but we may look at how the court looks at these and if they sort of draw parallels and sort of connect them, but also an implicit one, which is gender and race. We have in the decision confirming the charges, the chamber noted that violence against women could also be motivated by consideration connected with the color of skin, and that dark-skinned women were more affected by violence, especially in terms of punishment, than light-skinned women. And therefore, when one woman, the dark-skinned woman, was in a condition, in a special sort of place, which is different than all other women and different from dark-skinned men. And it is important going forward to see how the court sort of deals with this, to understand, especially in relation to victims, how the court sort of positions victims and whether it accepts sort of, several different harms, or if it really recognizes that one person and one individual may be in a particular condition, in a particular situation in which different harms actually are not just the sum of all the different harms, but they put this person in a special sort of place. And so I think I've really got to the end of my time. So basically these, I think, are the two most important issues that we want to look at Al-Hassan for: intersectionality and a definition of gender. Thank you very much.
Thank you, Vera, for finishing on time. Just for the information to the audience that Al-Hassan's trial is ongoing right now. So all these questions are very important. Basically, the definition of gender-based persecution is hotly debated, whether it depends on biological sex or it goes both ways, hotly debated issues, as well as what the court can do, how this case will define gender, and the point of intersectionality, how the court handles this issue. We all are waiting to see the judgment, right? Especially violence against women on the basis of color of their skin. It's very, very upsetting. And we have to see that how the court specifically deals with such intersectionality issues. So Vera, thank you for putting all these questions on the table. So with this, again, I thank you for your presentation. And now I would like to request Advocate Ziad Al-Maloom, one of the prosecutors of International Crimes Tribunal of Bangladesh. And he himself is a freedom fighter, a valiant freedom fighter of Bangladesh. He fought against the Pakistani forces in 1971. And now also he is fighting in the court to ensure justice for the victims. So he will be speaking on the international recognition of 1971 genocide in Bangladesh and a role of international crime tribunals in Bangladesh. Advocate Ziad Al-Maloom, can you hear me, sir? Advocate Maloom, can you hear me?
Sir, unmute করতে হবে, sir.
Okay.
Good evening. Thank you, Mr. Taposh Bol, Billa, and Vera. My thanks and gratitude on behalf of me and from the prosecution of International Crimes Tribunal of Bangladesh. Now, a little bit we'll look through what happened in Bangladesh in 1971, the very time when I myself was a university student. Now, this is March. In Bangladesh, the very ugly and horrific crime committed in Bangladesh on 25th March midnight in 1971. then the leader, father of the nation, Bangabandhu Sheikh Mujibur Rahman, declared independent, and after then Pakistan occupation forces captured him and arrested him and bring him to the Pakistan. The peoples of the general peoples of Bangladesh, they fought in a bunker hither in against the Pakistan occupation force, including here their auxiliary forces from the right wings of political parties like Nizam Islam, Muslim League, Jamaat Islam. And these political right wing for political parties, they formed with the help of the Pakistan occupation army as auxiliary force Rajakar al-Badr al-Assam. You see, Pakistani forces, they don't, they totally ignore about the topography of Bangladesh. Then in the whole 9 months, these Pakistan occupation forces along with their auxiliary forces killed 3 million of pupils, tortured and kidnapped and tortured. There are about 4 lakhs of our mother, sister, 2 lakhs were raped. Now, after war of liberation, Bangladesh enacted their own act in their parliament, 20 July 1973. The act for provide for the detention, persecution, and punishment of the person for genocide, crimes of humanity, war crimes, and other crimes under international law. Hopefully, if my understanding is not is that, so hopefully through the globe, it was the first parliament enacted international law in a country like Bangladesh. You see, after a long gap, already the Masum mentioned it, 25th March 2010, under this ICT Act 1973, Bangladesh established the International Crimes Tribunal and started investigation and prosecution and send the perpetrators to the trial. In the meantime, ICTBD already completed 42 judgments, till near about 36 trial is going on. Within this 42 judgments, most of the cases prosecution has successfully proved is beyond any reasonable doubt the crimes of genocide committed by the auxiliary forces and specific accused in the cases. I think so. How define genocide in Bangladesh ICTBD? Thank you. Sorry.
স্যার আমরা শুনতে পাচ্ছি আপনাকে স্যার
Sorry. Due to the net interruption. Sorry. I would like to mention it how define genocide in ICT Act 1973. The International Crimes Tribunal Act 1973 defines genocide as those acts that are committed against a national, ethnic, racial, religious, political groups with an intent to destroy wholly or partly by A, killing members of the group, B, causing serious bodily or mental harms to the members of the group, C. Deliberately inflicting on the group condition of the life calculated to bring about its physical destruction in whole or in part. D. Imposing measures intended to prevent but within the group. E. Forcibly transferring children to the group to the another group. It is very consistent with the International Geneva Convention as well as the Genocide Convention 1948. The definition and legal elements of the crimes of genocide are by and large similar to that genocide under Article 2 of the Genocide Convention 1948, Article 6 of the ICC Statute 1998. In the Bangladesh definition is an important over the convention definition. Professor Rafiqul Islam aptly mentioned that given the enlargement of the ambit of the definition of genocide, the inclusion of the political group in the definition of the genocide in 1973 Act bears contextual merit and does not appear to the inconsistent with the international law prohibiting genocide in all the forms and manifestations. ICT remarkably in three cases in 2019. One, a very renowned and an old Hindu communist leader, very near to the capital city, far from capital city, near about 60 kilometers far from political city. There, Mr. Ranoda Prasad Saha, the very renowned personality in Southeast Asia, there where he established a hospital, and in the Southeast Asia, where she established a residential school for the girls. He had contributed a lot of the things for the humanity in Bangladesh. In 1971, what happened? The local Dakar and Albodos troops, headed by Mahabub, kidnap and abduct Ranoda Prasad Shah from his house at Mirzapur.
Sir,
Then,
you have 2 more minutes, sir. You have to wrap up with 2 more minutes.
Sorry. You see, in that case, court, International Crimes Tribunal mentioned that the nation can never forget the wrongful scar experienced in 1971. Global community is now expected to stand up and recognize that genocide happens in Bangladesh 1971 and also to raise voice by saying never again, never again. My conclusion is that obviously international community to attract the international community, Bangladesh government and the Foreign Ministry of Bangladesh with the help of 3 and 4 judgment from the ICTBT and making to organize the make the propaganda and bannered it in the community to recognize Bangladesh genocide. Thank you all.
Thank you, sir, for your wonderful paper and for your submission that recognition is necessary, firstly, for the perpetrators so that they do not repeat same kind of atrocities. Yes. And from the Bangladeshi perspective, recognition is necessary for the trial of the perpetrators who are living abroad. So before I take up questions, the floor is open for question and answers. I would like to say that we have Dr. Helen Jarvis, Julian Fellman, Tapush Dash, Bayajid Hussain, and Mohammad Abdur Razak in the audience. And I would also like to say that this wonderful international conference is organized by Liberation War Museum to commemorate the 50th year of independence of Bangladesh. So if there, I do not see any question answer, but I would like to put a question from my end to Vera, that Vera, what do you think that how ICC will respond to this gender-based persecution? Because it was only recognized in refugee law. It was so far not defined. So what would be their approach in defining this gender-based persecution? Yes, Vera, do you want me to repeat the question?
No, I'm good, thank you.
Okay.
Thank you for your question. I think that there's, I mean, I don't know obviously which way they're gonna go, and it's likely, I suppose, that you know, I mentioned the definition by Valeria Osterveld of constructive ambiguity in the statute, and I suppose that it's possible that they will also be a little bit ambiguous and not sort of, you know, give us definitions that are that can open the stage too much. But at the same time, I do think that there's a that the court will take some sort of stance. And I'm thinking about the decision confirming the charges, in which, for example, when talking about the concept of on the basis of gender, the court mentioned the ICTY in COPCA, meaning that saying that it is about a different treatment of men and women, but also mentioned CEDAW, so the Convention for the Elimination of Discrimination Against Women, and it mentioned that violence directed at women is such because they are women, so because of their gender, in which case could also be signified as simply biological sex, or that affects women disproportionately. So that already shows a little bit of an opening of how we intend persecution, because that really means that the organization, so Ansar Dine, that Al-Hassan represents here, targeted women, imposed disproportionate sanctions on women, and exerted gender-based violence as punishment, so something that can only be done towards women. And especially one thing that I think that is very relevant in relation to the intersectionality problem is the fact that they did mention the dark-skinned women being more sort of affected by it all than others. They do mention that the the punishment towards dark-skinned people was something that was real and true across the board. So also dark-skinned men were more likely to be punished than light-skinned men. But at the same time, just the fact that they sort of mentioned it and put it there, even though race was not on the table technically with the charges, I think it really shows that they do have, that there may be, at the very least, a tendency for the court to open things up a little bit, I think. So I don't think that everything that the commentators want, especially in terms of what gender is, or whether that it will be able to include sexual orientation as well as gender identity and all of that, I don't think that we'll really have all of these questions answered in this case specifically. But just the fact that finally one of these charges was confirmed, and that in my opinion, reading the decision confirming the charges, there's a little bit of opening towards, at the very least, mentioning controversial topics. That shows that there's some, a little bit of opening towards discussing them, even though they are in my opinion, they're probably likely to keep a little bit of ambiguity in there. So that would be my answer.
Thank you, Vera. Just a quick question that if gender-based persecution gets recognition, do you think that genocide by rape, right? Maybe the prosecution day by day will be reducing charges on rape-based genocide. What do you think?
Well, this is
there a
certain.
possibility that? I mean, this is from the mindset of prosecutors.
Well, I guess that this may be one of those problematic things, especially when we talk about the sort of expressive role that courts have, and when we and of not wanting sometimes to dilute the terms that we use too much, exactly because things like this can happen, and something that might for all intents and purposes be considered genocide, but then because we sort of open it up to other things, for example, crimes against humanity, which may, well, especially because of the special intent that genocide requires, and with crimes against humanity, and it's a bit easier to prove because we don't have that high threshold. I think that it is a possibility. Then one who could make a choice that it's more sort of political or pragmatic to go after persecution rather than going after genocide. So that is a distinct possibility. At the same time, though, I think that not allowing or not sort of looking at persecution on the basis of gender as a distinct possibility as well, that also risks leaving way too much sort of outside of the jurisdiction of the court. So there's risks connected with it, and I totally see your point. But I think that at the same time, it's probably a risk that we need to take in order for severe violations of human rights that could just be left out of the jurisdiction of the court with no redress of any kind being available to victims. So it is risky, but it's probably, hopefully the payoff will be that victims will have some sort of redress, and that's hopefully will be good enough, at least until we get to a...
Okay, thank you, Vera. My next question is to Professor Billa, Dr. Billa. Dr. Billa, you mentioned about 3 dimensions of alibi in Bangladesh ICTPD trials. Is there more dimensions in other trials, because you have done a comparative study? So, and if it is yes, then how many dimensions do you find of alibi in other trials, especially in ICTY and ICTR?
Yeah, thank you for the question. And I also want to extend my thanks to my co-presenters for enlightening some other areas. To answer your question, I haven't found any specific dimension coined by the ICTR and ICTY. As I have mentioned in my presentation, that they have offered competitive interpretation. So my submission and argument is that we always talk about international standard and fairness. For example, I have referred to Robertson's report of 2014, where without any further in-depth study, he has just criticized the Bangladesh tribunal. What I mean that in different cases, the ICTY and ICTR has come up with different set of approaches towards the question of alibi seen from the perspective of procedural fairness. As such, the doctrine is still under construction internationally, especially in the field of international criminal law. Therefore, I have submitted that the national jurisdictions has a role to play in order to fill up the gaps. And I have referred Australian practice, England practice, American state practices, as well as the subcontinental practice. You may be aware that the evidence law in Bangladesh has been prevailing from British period, and the same penal evidence law is followed all throughout the Indian subcontinent. And the practice is more or less same elsewhere in the common law jurisdictions. So what I mean that it is actually sometimes misquoted, and without reading Bangladesh's political, cultural, and socio-economic perspective, these scholars are criticizing it. I have discovered a tendency that at the earlier phase, Bangladesh tribunal faced political criticisms. Now the criticisms have been diverted to legal dimensions. It has been the subject matter of investigation in different parts of the world. In different universities, there are research works going on. What I appeal towards the audience, especially to, I see many law students joining this session, that just simply giving one example of the practice of alibi, I have shown that actually Bangladesh practice does not fall short of the international standard. There is nothing standard which is unachievable in the name of international standard. It must be condition specific and socio-economic political context specific. As such, my appeal towards the students, especially who are the future researchers, is to study the Bangladesh judgments and also place it in a very reasoned manner so that the international community can be much more briefed about our war trial and process.
Okay, thank you, Dr. Billah. I'll just have 1 minute time now to ask Advocate Jihad Al-Malum, Senior Prosecutor, International Crimes Tribunal. Sir, can you hear me?
Yes, yes.
Just a last minute question, because you have submitted that there is no lack of political will from the perspective of Bangladesh government for international recognition. But do you think that the government officials, especially Ministry of Foreign Affairs, are doing enough to get the international recognition, or do you think that they should be doing some more proactive works? You have any suggestion for them?
Yes.
1 minute, sir.
Yes, yes. On behalf of the prosecution, as also one of the freedom fighters, Bangladesh government already take the resolution, take the recognition and resolution in the parliament 25th genocide of 1970 to 25th March. Now, Bangladesh Foreign Ministry have took the liability and took the charge with the help and with the help of with the mentioning there are 3 and 4 judgment passed by the ICT, and ICT also asked the mankind and the humanity, the world, to recognize the Bangladesh genocide. Now at time, Bangladesh Foreign Ministry obviously look it into a serious agenda, and they start to organize to take initiative from the UN organ to the others concerned peoples of the humanitarian peoples of the world to recognize Bangladesh genocide by UN.
Thank you for finishing the answer within the time. So just 2 minutes left of our session. I will take this opportunity to thank Liberation War Museum to organize this wonderful and successful international conference, and which is going to last for 24 hours and will be taking place in different corners of the world. This is a great opportunity for the researchers, for the academians and activists to participate in these international conference and to know a lot about transitional justice, international criminal law, and the legal position of the states in atrocious crimes. I would like to thank Liberation War Museum to give space to empowerment through law of the common people so that they can organize this session. I would like to thank the speakers, Advocate Jihad Al-Malum, Senior Prosecutor, International Crimes Tribunal, Dr. Masum Billah, Assistant Professor of Law, Jagannath University, and Director of ELCOP, and obviously Vera. Thanks a lot for taking time and to speak before us, and also the wonderful attendees who participated in this session. Thank you all. And finally, I would like to thank the organizers, the students and the volunteers who are working relentlessly to make it a success. Thank you all. Thank you.